So looking at the different types of intellectual property protection that you've mentioned, could you tell us please in more detail about the features of patent protection?
Right, well, patents are granted for new inventions. Now, new means that at the date the patent application is filed, it must never have been disclosed publicly, never have been sold, never have been used. And it must also be inventive. That means it has to have some spark of genius over what's been done before. Now, the spark doesn't need to be huge. You don't need to be someone with a string of degrees to be an inventor. The ordinary man in the street can make inventions just like anybody else. You just have to have an idea that nobody else has had before, and it has to have some little spark.
Can you describe, please, the various stages of the patent process?
Oh, certainly. The most important thing is to establish a date, because the date of the filing of the application is the date at which the novelty, how new it is, its inventiveness, whether it's obvious or not, is always going to be judged. Now, to get to that stage, you have to describe the invention in detail, the features which make it different from what happened before, and you also have to explain in detail how to make it, how to do it, how to put it into effect. The reason for that is that a patent is a bargain between you and the state. In return for you getting a monopoly, and monopolies are normally bad things, but in return for you getting your monopoly for up to 20 years if you pay the renewal fees, you have to do something as the inventor, which is to disclose to the public how to do something they didn't know how to do before. In other words, you're disclosing your invention. It's in return for that disclosure that you get any rights at all. Otherwise, you could have kept it entirely to yourself.
As a new inventor, how would I prepare myself to come and talk to you? What would you expect an inventor to do in advance of your meeting?
Right. The inventor needs to come to me with not just an idea. An idea is not an invention. It's an invention waiting to be made. You've got to know how to actually make it, how to do it. You don't need to have built the prototype, but it's certainly useful if you've got some good sketches, assuming that it's a mechanical article. And if it's a more complicated thing like a software program, you need to know how the logic diagram works, even if we haven't coded it at each stage.
And what would really be the next stages in working with you to move forward in the patent process?
Well, it's usually a good idea to have a meeting, because that way I can probe you, and you can find out whether you like me as the inventor, because you're going to live with me a long time if we do decide to go along the lines. And then once I've got a fair idea of what it is and how it works, I'll usually suggest that some sort of searching should be done to make sure that it really is as new as the inventor thinks. It's fairly easy to do this kind of searching. It can be done by an amateur on a wet Sunday afternoon sitting in front of their computer on the internet. There's some very good websites that I can show people how to use. The reason for this is that it generally costs £1,000 to £1,500 typically to file a patent application, all of which is paying for the patent attorney's time. And if you're going to spend that sort of money, if you're a sole inventor or a small business, you want to have a reasonably good idea that it's going to do you some good. You can get professional searches done, but good professional searches, plus a patent attorney looking at it afterwards, it's going to cost you very nearly the same amount of money it would cost you to file the patent application in the first place. So it doesn't make sense, for example, to spend £1,000 to decide whether to spend another £1,000 on filing the patent application. And the other problem is that patent applications are only published when they're 18 months old. That means that every search you do inevitably comes with a health warning. It's incomplete. Inevitably it's incomplete because of the nature of the system. You can't look at the most interesting bit, what people have filed in the last 18 months.
How does the patent process vary around the world? And if I'm a UK inventor, how do I get myself protection in other areas?
Oh, that's easy. There's an international convention which has been in existence for well over 100 years, which says in effect if you file in one country, you have up to 12 months to decide whether to file in any other country, and if you do so, you can then claim effectively the date in the first country. So in other words, if we file a British case, you can file a United States case in a year's time, and you effectively get the British date.
Now, is that something that you would do for me as well?
Oh, yes. I have contacts in virtually every country in the world. My business is virtually the most international there is. I know people virtually everywhere. There's no country I can't find a patent attorney to instruct on your behalf.
Now, I've heard rumours that in some countries it's easier to obtain patents than in others. What are your views on this?
By and large, it's roughly the same. Most countries have the same rules of having to be new and having to be inventive. It's a question of how they're interpreted and also, to some extent, the practice. There are a few countries that take the easy way out and simply grant patents as you file them. South Africa is a good example. And leaving the onus on the applicant to make sure they don't maintain a patent that is broader than justified. Whereas other countries like the United States or China or Europe or Japan will examine applications in elaborate detail to make sure that the grant is justified before they'll actually grant it. This, of course, means that the examination process can take quite a few years.
From date of filing, then, it would be prudent to allow in planning that it will take several years before the patent is granted.
Absolutely. But in most countries, if anybody were to infringe your patent, that is, fall within the scope of what you say the invention is, after the patent application has been published, which is at the 18-month date usually, and it's 18 months from the first date, not the actual filing date in each country, it's 18 months from the first date usually, damages can be counted back to that date. So eventually when the patent's granted, you can turn on people if they have been copying you and say, look here, chum, you've got to pay me for all this, all these sales you've made up to now.
The real benefit of patents, it's preventing others from offering the same service or product and then being able to claim damages. Are you able to assist in that process if and when required?
Yes, of course. I mean, indeed, that's the only purpose of patents. Patents do nothing else other than disclose the invention and give you the possibility to stop other people. They certainly don't guarantee that you're going to make any money. Quite a few patentees, I have to say, unfortunately don't. A lot depends on the marketing exercise and how well designed the product and so on as to whether it meets a niche in the market and sells. All the patent does is, if you are copied, gives you the possibility to stop somebody.